May please, my lord.
Give us only 1 second to. The electronic housekeeping work has been carried.
May please, my lords. My lords, my written submissions are volume 2E.
Volume
2E. My lords, first I'll take the issue of intoxicating liquor under entry 8. These two, my lords. That is at page 21, para 34. My lords, Constituent Assembly debates were referred to, but the page 21, PDF page 21, para 34. My lord, this CAD debate was not pointed out, my lords. This is in relation to Article 47 of the Directive Principles, my lords. And in intoxicating liquor and intoxicating drinks have been interchangeably used, my lords. If my lords have it at the bottom where I've quoted, this is Honorable Sri B.G. Kher. He says, I do not wish to speak at length on prohibition because after very deliberate consideration and prolonged discussion, most of the provincial governments and most of those who are interested in the progress of this country have accepted the necessity of protecting our people from going to their ruin by the use of intoxicating drugs and liquor. My lords may note this one. The use of intoxicating drugs and liquors do not affect the moral sense of a person who uses them. Therefore, it is in the sense of beverage, my lords. Then, my lords may have on the next page, para 22, it continues, my lords. The very object of introducing the amendment, which I am very happy to find has been accepted by the Honorable Dr. Ambedkar, who is in charge of the bill, is to prevent the furtherance of vice. It is argued that the use of intoxicating liquors and induces drugs. So, intoxicating liquor and intoxicating drink have been interchangeably used, my lords. This has also been noted by Mr. Sirvai in his books.
So liquor, intoxicating liquor and liquor has been used.
Yes, an intoxicating drink, when ultimately Article 47 came, it used the word intoxicating drinks. So intoxicating liquor has been used in that sense only, my lords. And Mr. Sirvai's quote has been already pointed out to my lords. And that's why I'm not repeating that. That is in paragraph 38 of my written submission, my lords. My lords, directive principles, all the fields, my lords, have para 35 for a moment, my lords. The fields enumerated in the directive principles find place by and large in one or the other lists of the 7 schedule, my lords. Article 47, I have given appendix 2, my lords, which is at page 41 of the written submissions, my lords. This gives the comparison of which are articles and which is the legislative entry. But page para 20, para 35, read with appendix 2. That is at page 41, PDF page 41. And let's, the only thing one I would like to point out, the most important entry has been missed out in this appendix, my lords, which my lords may add at page 44, serial number 11. Entry 8 of list 2 has to be added in that, my lords. This has been missed out. in the comparative chart appendix 2, my lords. Now coming back to
Yes.
my lords, if entry 8 talks about intoxicating liquor, my lords. If alcoholic liquor has to be added in that, it has to take color from the other entries in the same list, my lords. And I'm saying so because when the Law Commission report recommended that all alcohol be included in the state list, that was not accepted by the Parliament, and they restricted only potable alcohol, and non-potable alcohol was under the IDR, my lords. Therefore, they were very much conscious of the fact that state has only the power to the extent of potable alcohol and no further.
Yes.
My lords, next point is power to legislate on 245, 246.
So we'll take it as a second point.
Second point is the scope of 245, 246, and 254. This is at page 6 of my written submissions, my lords. Paragraph 4.
Tell us that again, please.
Paragraph 4, I have summarized 240. My lords may have 245 and 246 for a moment. Then I come to that, my lords.
Page.
My lords, Constitution, my lords may have it.
Okay.
Article 245, 246.
Why don't you tell us what's
My
the
lord.
point that you're making?
246, 1 and 2 starts with notwithstanding, that is non-obstante clause, and clause 3 of Article 246, subject to, my lords.
That's just
And this is the enabling provision to make laws. My lords, when we go to Article 254, then the test of repugnancy will take place vis-a-vis the state law, my lords. And if a law, Parliament has made the law, then to that extent, the state will be denuded of its power.
45.3, you're right, because
Right.
we have discussed it. Yeah,
Right, my lords.
What is the next point?
My lords, now here, once the field is occupied, my lords may have 162, Article 162 for a moment.
The point you're making?
My
That the
lords,
executive power of the state is
even-
coextensive with the
No,
legislative.
my lords, proviso to 162 is very important.
Yes.
May I read, my lords? Provided that in any matter with respect to which the legislature of a state and Parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. In my humble submission, my lords, under the IDR Act, specific executive powers have been conferred on the central government, my lords. Like in 18G, it can notify, then there are other provisions. So once that power is there, the state is denuded of all its power, including legislative and executive power, to make laws in respect of IDR Act, my lords. In this regard, my lords, there is one constitution-based decision, 2016, volume 7, SCC 1.
Where is it? Where do we find it in the compilation?
It is not in the, because it was
what does it
I
say?
have given 2016, 7 SCC, page 1,
Yes.
Union of India versus, my lords, para 140. My lords may have it. I won't read the entire discussion, my lords. Para 140.
What is the point that you are stating?
My lords, the executive power under 162. Because my submission is the act has been enacted under the legislative power and the executive powers under the act have been conferred to the central government, my lords. Therefore, the state is denuded of its power even in respect of executive matters, my lords. My lords may have para 140 at page 117. Thirdly, my lords got it? Thirdly, a situation may arise where the authority to bring about a law may be available both to the union as well as the state, that the law made by the parliament may invest the executive power with the center, while the state may also enjoy similar such executive power by virtue of a law which the state legislature was also competent to make. In these situations, the ratio laid down by this court in the decision in so and so will have to be applied and ascertained which of the two, namely either the state or the union, would gain primacy to pass any order of remission, etc. In this context, it will be relevant to note the proviso to Article 162 of the Constitution, which reads as under. After the quotation, my lords, if the proviso applies to a case, the executive power of the state should yield to the executive power of the center expressly conferred by the Constitution or by any law made by Parliament upon the union or its authorities. Therefore, in my humble submission, the entire power, may be it legislative or executive, that has been taken away from the state by enacting IDR Act, my lords. The other relevant paragraph is 173.11. 173.11, where they have summarized, my lords. I'm not reading that, but this is the main.
The Article 73 proviso, huh?
Yes, my lords.
The proviso to Article 73.
73. It's quoted, my lords, in this. 73. Yes, my lords. 73 proviso. Provided that the executive power referred to in subclause A shall not, save as expressly provided in the Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also power to make laws, subject to the laws made by the Parliament.
So, if it's a field in the concurrent list,
Yes,
then even if it is a union law,
yes, my
the
lord.
state has the power, executive power, unless that law provides otherwise,
Provide.
expressly.
Expressly. And in my humble submission, the entire provisions, if my lord reads the entire act, the entire executive power has been vested in the central legislation. My lords may have sections 25 and 26 of the IDR Act for a moment. The other provisions?
This also we must also take into account
Yes, ma'am.
what is provided in the IDR Act,
Yes, my lord.
what is specifically excluded out of the
Yes,
IDR Act.
My lord.
Now, when it says fermentation, and we have
Yes.
gone through it many times, fermentation industries other than potable
Yes, my
alcohol.
lord. Yes.
So we must understand, I mean, that potable alcohol part
Yes.
would always remain. with the
Yes,
states,
I'm not on that. I'm not on that. Potable alcohol is within the domain of the state legislature. I'm
saying
restricting
that in the context of denatured spirit,
non-potable, my lord.
Denatured,
Denatured is one
let's-
of the species of non-potable, my lord.
let's use the expression denatured spirit.
Yes, my lord.
In case of denatured spirit,
It is with the union.
The Union of India.
Yes.
That's the
Yes.
proposition
Yes.
that
Yes.
you are
My lord,
explaining.
I'm not restricting to denatured because non-potable
This
is the
where we-
non-potable is the correct phrase, my lord, because they've excluded potable. Potable means safe for drinking. The literal meaning of potable is safe for drinking. I don't have to go to any dictionary for that, my lords.
So are you saying that potable can be equated with the subject in entry 8,
8,
intoxicating?
intoxicating liquor. And that is why when it was recommended, Law Commission report recommended to include entire alcohol in the state list, entire alcohol outside the IDR Act, that was rejected by the Parliament.
Because intoxicating liquor within the meaning of entry 8 is for drinking
Beverage.
purposes. It's a beverage
Beverage
for-
purpose. I am obliged, my lord. So my lords may now have sections 25 and 26.
So for industrial.
This is-
Section 25 and
Section
26.
25 is the delegation of powers. My lords, the center can delegate the power, and to that extent, my lords may have section 26 for a
Got it.
moment.
And directions.
Directions, and directions have been issued in the instant case, my lords, post 2016 amendment. My lords may have volume 4A, PDF page 489. In fact, I have quoted the relevant portion at page 48. Page 48, paragraph 26. Para 48, page 24, my lords. My lords got it? Volume 4A, page 489. And the relevant portion has been quoted in my written submissions at page 26, para 48. Page, PDF page 26, para 48. My lords, I was at para 48 of my written submissions at page 26, where a specific direction post 2016 amendment has been issued. Relevant portion I have quoted, my lords. In a present circumstances, my lords, may I read the direction itself? That would be sufficient. Now, all issues pertaining to fermentation industries other than potable alcohol, such as control over its licensing and regulation of the manufacture, storage, acquisition, possession, use, consumption, transportation, trade and commerce, supply, distribution, and its movement, including intra-state and interstate movement thereof, and the grant or issue of such license, permit, or other documents, and charging stroke levying of fees, if any, etc., shall be under the exclusive control of the Government of India. Further, any such control by state governments over the field indicated above, including on intrastate movement of industrial alcohol, that is other than potable alcohol, or alcohol for EBP program, stands repugnant to the amendment issued by the central government, wide amendment dated 14/5/2016. So all the powers with regard to non-potable alcohol, directions have been issued in exercise of the powers under 26 my lords. And many of the states, including the state of Maharashtra and Punjab, have accepted this. I have annexed those in volume 4E. Minutes of meeting and the acceptance by various states, including Maharashtra, Punjab, and various other
That's
states.
all right. Whether they accept it or not, we have to go by the constitution.
Yes, ma'am. So
This
this
What is the next point? We'll hurry along now.
now, my lords, 18G is one of those executive powers, my lord may note, because the entire gamut of their argument
So,
is
your third point was section 25 and 26, or third point was article 162.
162.
Okay, just a second.
In 162, my lords may note, section 18G was specific that it is with the central government.
18D.
18G, G for
Yeah,
Goa.
yeah, that we have seen.
Yes.
Then your fourth point was section 25 and 26 of
Right.
IDRA.
IDR Act.
What is the next point?
My lords, next point is, my lords, we have the first schedule for a moment, my lords, of the IDR Act.
What is the
My lords,
related?
the product which are mentioned are in the exclusive domain of the central government, my lords. My lords, may have first schedule for a moment.
There's no doubt about this.
My lord-
Exclusive domain.
My lords, may give me 2 minutes. I'll explain what I have it in mind, my lords.
Just formulate the point and
Fine.
then tell us.
My lords, the first schedule opens with any industry engaged in the manufacture or production of any of the articles mentioned under each of the following heading or subheadings, namely. So any of the articles which are being manufactured will fall within the schedule industry. And 26 says fermentation industry other than potable alcohol, and the products are alcohol and other products of fermentation industry. So it is specific that non-potable alcohol is in the exclusive domain of the central government, my lords, union. Because the product as such has to be seen, not its ultimate use, or it can be diverted, or it can be used. The product which is being manufactured is non-potable alcohol, and it has to be seen as such, not its potentiality, my lords. Potential use is not the key test over here, my lords. It is the product which is being manufactured is the relevant factor.
Or potential misuse.
Use of, just a passing thought.
Yes.
Use of beer
Yes, my lords.
for washing your hair, will it be misuse or use?
My lords, it depends. If it is healthy, then it will be used. Because while washing, one can also have the beer as such, my lords. So it's both use and misuse.
think beer shampoo is not intoxicating, I have.
It's not.
But there will be use and abuse also.
My lords,
See, while making, they sort of, they sort of siphon off the intoxicating part of the product and was washed away.
my lords, my learned colleague says using beer for shampoo will not make it a beer as such, because then only beer is not there, something else added to the beer for using as a shampoo, my lords. It would not be as on the
So
list.
that this is the next products in the first schedule are in the exclusive domain of the central government.
Yes,
And
ma'am.
the opening words, any industry engaged in the manufacture or production of any article.
Article, because there are certain entries, my lords, where all the articles which are capable of being manufactured by the scheduled industry is not covered. My lords, may give me a moment, ma'am. My lords, the legislative history of IDR Act, because industrial alcohol has been loosely used, that was the argument. Industrial alcohol was in the original act, my lords, of 1951. My lords, I have given the compilation of the legislative history of IDR Act in volume 4F. Four F, my lords.
What else?
My lords, industrial alcohol in power and industrial alcohol was in entry 24 at page 31 of the volume 4F.
Wait, just 1 second. Let's go to that.
In fact, I have summarized in the list of dates in the opening page itself of 4F, my lords.
Yes. Page.
Page 1 itself, my lords may have it, volume 4F. And the supporting documents are there, my lords. On 26 March 1949, when the bill was introduced, the draft entry was 18 in the first schedule, power and industrial alcohol. In the 49 amendment bill came, and the entry was 24, but it remained as power and industrial alcohol.
While you're making an important point, just let's quickly run through it. So 51.
51
the bill was power and industrial
industrial
alcohol.
alcohol. Then an amendment was made.
Before the amendment,
Yes, ma'am.
came the Act in 1951,
1951.
where it was item 23, power and industrial alcohol.
Yes, my lords, at page 31.
Then came the
1956 bill, my lords. This is very important. 1956 bill, page 93 at 95.
then entry
Entry 25 at page 98.
became fermentation industry.
No, my lords, fermentation industry, and then 1 and 2, alcohol, dash, industrial and power. My lords may note, this was in the bill. When it came to the Lok Sabha in debates, my lords, PDF page 152. Page 150. Right hand side, my lords, right hand side column, about 10 lines from the bottom, my lords. Page 8. Have my lords got it? Page 8. Right hand side column of the Lok Sabha. These were the amendments which were moved. PDF page 152. Sir, I beg to move to page 8, 2I, II. Line 12, omit industrial and power. So the amendment was made to remove industrial and power. And the reason was, this is intended to remove a printing error. Page 152, right-hand side, towards the bottom, it says paragraph 2, 2I, II. In line 12, my lords, it starts, sir, I beg to move. So, my lords, page 152 of the PDF, my lords. PDF,
Starts with on the right hand side, Industries Development and
Regulation Act. Yes, my lords.
Is that
Then
what you're
towards the
saying?
bottom, towards the
Towards the
bottom.
Bottom continues in Hindi.
Yes. Then thereafter,
So 154 we go to.
2 and II. PDF page 152. Printed page 149. Printed page 149 towards the right hand, about 8 lines from the bottom, my lords.
Hmm?
II. Line 12, omit
Industrial and power.
49.
Or omit.
industrial and power. These are removed, and the reason for removal is, this is intended to remove a printing error.
What is it?
That was industrial and power had to be removed, my lords. Only alcohol as a whole was to be there. The bill said alcohol dash industrial and power. So industrial and power has been removed and the entire alcohol was included, and that was the position till the 2016 amendment. This is how alcohol was introduced. So this alcohol meant both potable and non-potable.
In the original act, it was entry 23.
Yes, my lords.
Which says power and industrial
Industrial
alcohol.
alcohol.
1 second. Right? Then comes the 1956 amendment.
Meant,
It entry 26,
yes.
which is fermentation industries dash alcohol.
Fermentation industries, then 1 and 2.
No,
Yes,
we've seen
alcohol.
it. That
Yes.
is alcohol.
Alcohol.
And then 2016,
In
it is entry 26 is substituted as fermentation industries other than potable.
other than potable alcohol. So now it is restricted, and this is a retrospective amendment from the date of the act itself. So my learned friend, Mr. Datar said the amendment came in 56. So how can it be retrospective since 1953? So this is the legislative history and how it has been made retrospective from 1953.
Now,
my
just 1 second, so that later on when we are dictating, we don't have to start hunting pages.
Yes.
1951,
Yes.
the original act.
Yes.
What is the PDF page in volume 4F? Just tell us.
4F, it is page 1 at 31.
Page
Sorry, page 36 at 42. Volume 4F, page 36, PDF page 36 at page 42.
All right. Then the 1956 amendment, we'll just look at it,
Yes.
in a
Yes.
fraction of a moment.
Yes.
1956 amendment, where
Bill.
entry 56 comes. Don't forget the bill now.
Yes,
You
ma'am.
didn't even
Yes.
confuse ourselves with
Yes,
the bill.
it came from 1st March 1957.
What is the PDF page?
It is not, act is not here, my lords.
All right, it's not there. Fermentation industries, bracket
Al-
1, alcohol at the bottom. And then 2016, we of course have it,
Yes.
but give it to us again.
Yes, 2016 amendment is 4B, page 576.
Volume
4B, B for Bombay.
B for Mumbai.
B for Bangalore, Bangalore.
All right.
M for Mumbai.
4B
B.
page.
Page 576.
All right.
So, my lords, in my humble submission, potable alcohol as such is covered by, and the product which is manufactured from that industry has to be a non-potable alcohol. So, its use or misuse, my lords, will not determine the legislative power, my lords. My lords, I have given the, my lords, IDR Act is in in exercise of two legislative fields, my lords. One is entry 51 list, 52 list 1, and the second is entry 33A list 3, my lords. Entry,
What's the next point now?
my lords, I am on that only. My lords, IDR Act is a complete code. Declaration is under section 2, which is deriving power from entry 52 list 1. Rest of the provisions of the Act derive their power from entry 33 list 3 of the Constitution, my lords. My lords, entry 33A, 33 says trade and commerce, supply, distribution, and production. My
What's the point now?
My lords, so all these points have been covered. I am only pointing out Appendix 1, which I have in my written submissions, my lords.
Appendix 1 to your written submissions?
Written submissions.
What does it say?
I have tabulated which field is covered by which provision, my lords.
Which?
Which field under entry 33 is covered under which provision, my lords? PDF page 40.
Where will we get Appendix 1 page?
In my written submissions at page 40. PDF
Volume.
page 40.
2E.
2E.
Go to that.
Page 40, my lords. So all the fields, legislative field under 33A is covered, my lords. I'm not going through the act. My lords.
Now
Only-
what remains, Mr.
Only two
Agarwal?
points, only 2 points.
Only 2
rebuttable.
points.
My lords, one is stay decisis, my lords. It has held the field from 1989, my lords.
Synthetic.
Synthetics.
Synthetic.
And the amendment has been effected in line with that, my lord.
1 second.
It is
1989 was the judgment,
judgment.
Reported it.
reported in 1990.
All right. And last point.
My lords, and I have given the list of judgments, Appendix 4, which have followed synthetics, my lords.
1 second. Let's make a note of that.
Lord, this is a classic case.
Appendix 4, page
Page, I'll give my lords, Appendix 4.
page 50.
Page. My lord, this is a classic case where the decision of this honorable court has been accepted by the government. Parliament has enacted a law in line with the decision of this honorable court. And the executive has also followed it, my lords. Apart from the various courts which have relied upon synthetics in the last 34 years.
A classic case, rare case.
Rare case. This is the only case which I could find where the government has accepted the
All
judgment.
right. What last point?
Yes. My lord, there were two arguments made by the other side. One by Mr. Jaideep Gupta for State of Bengal, that that would be an administrative chaos. My lord, administrative chaos cannot be a ground to justify whether the legislative competence, my lord. Is sentence in the judgment of this honorable court in B. Prabhakar Rao, my lord, when you have stirred the hornet's nest, should be ready to kill this thing. My lords, if my lords want, I can give the citation. I'm not reading that, my lord. That is 1985 Supplement SCC 432, para 20 at 462.
Supplementary 4 SCC. is it?
Supplementary SCC 432. At that time, there was only one supplementary volume.
And para?
Para 20 at 462, quoting Lord Denning, my lords. And then this was later relied on 2014 4 SCC 720 para 70.
2014 4 SCC.
CC 720 para 70. 70.
The earlier judgment, is it in the compilation?
No, it's not. It's
Second one also is not.
I'll give.
All right. Thank you, Mr.
My
Agarwal.
lords, one more thing. My lords, Mr. Balbir Singh, while appearing for Maharashtra, said we are following BIS standards of denaturance, my lords. My client used BIS standard and is being prosecuted because they say it is our standards which have to be taken and not BIS standards. Keep your well.
You are satisfied now that you've given me a full hearing.
My lord,
Thank you.
the only thing is, my
I
lord,
must compliment you. You are also very precise and absolutely on the point. So we
my
appreciate.
lord,
Thank
I
you.
may be permitted to file a 2-page.
No, now don't file 2 pages. Now you've filed so many pages before.
Deeply obliged.
Yes, Mr. Bhandari.
Well, I'm only going to take 5 to 7 minutes. I filed a very short note, which is at volume 2H. Well, my other submission can be ignored because it will be repetitive to what others have filed. I filed now 2H, Millards, which is a very short note. Volume 2H.
Volume
2H.
And I had already told my lord, the Chief Justice, about Mr. Nariman, Lord, but the most oft-quoted couplet in Urdu about alcohol is that, Zahid means, the cleric means, and it said, "मैं Zahid शराब पीने थे मस्जिद में बैठकर या वो जगह बता दे जहां पर खुदा ना हो.
Beautiful.
Look, my first argument is that the decision of Bombay High Court in Balsara is the right decision and gives the correct interpretation to the term intoxicating liquor. And that's para A of my note. Bombay High Court reasons this in about 4 or 5 or 6 lines, and I've quoted that exact paragraph. If my lords looks, my lords, it says in the first instance, liquor ordinarily means a strong drink as opposed to a soft drink, but it must in any event be a beverage which is ordinarily drunk. Now, the other side wants to argue that the term liquor comes from liqueur, and therefore please extend it to also include liquids. But if one looks at the constitution itself, the constitution in entry 53 list 1 uses the word liquids. So liquor and liquids cannot be interchanged.
Where does the constitution use? Yes, of course.
Yes. At entry 53 list 1, liquids is a term used in a non-consumption manner. So therefore, to extend liquor to mean liquids, the answer is in the constitution itself, because constitution uses the word liquids when it wants to use the word liquids. That's at entry 53 list 1. So as far as liquor's definition given in Balsara's High Court judgment, meaning a strong drink, that's the correct one. Then second reason why Balsara High Court states that it's for human consumption is because then it goes on to define what is the meaning of the term intoxication. And it says, very interestingly, in the second place, the use of the word intoxicating in item number 31 in contradistinction to the use of the word alcoholic in item number 40A as qualifying the word liquor is very significant. We may also point out that in the white paper, item 26, which corresponded to entry 31, used the word alcoholic liquors, which have in Government of India Act been changed into intoxicating liquors. Therefore, it is apparent that from the class of alcoholic drinks, non-intoxicating drinks are excluded by this entry. Thirdly, medicinal and toilet preparations containing alcohol which are found in entry 46 are neither liquor nor intoxicating, and therefore they are obviously excluded from the scope of item number 31. So, my lords, there it reaches the conclusion why intoxicating should be something for human consumption. My lords, then if one steps back and looks at Article 47, why is entry 8 worded in the way it is worded? If one looks at entry 25, one will see that when they wanted to do gas and gas works, they said gas and gas works full stop. But when they drafted entry 8, they gave it with full splendor. That is to say production, manufacture, supply. That is because if one steps back and looks what the state is vested with, the state is vested with every power to achieve and fulfill what Article 47 Directive Principle mandates it to do. Therefore, entry 8 had all these words to ensure that if state wants to fulfill its objective under 47, it can do that and has enough powers there. That's why entry 6 also public sanitation is with the state. And more importantly, entry 51 list 2 gives state full power to levy excise duty on potable alcohol. So this all flows from 47, because to achieve the purpose in 47, entry 6 public health and sanitation, entry 51 tax on excise duty, and lastly but not least, entry 8 list 2, which is that is to say production, manufacture, supply, everything is vested as far as potable alcohol is concerned with the state, so that it can fulfill its objectives under Article 47. So my humble submission is that the definition of intoxicating liquors, one can see what it means by looking at the Constitution itself. Then, my lords, I cite after that, there was an argument made that if you look at the Indian Government Act of 1935, and you look at the local acts in and around that period, then intoxicating liquor, especially liquor, could mean liquids also. But my lords, the only point I'm making here is that even under the Indian Government Act, there was a Power Alcohol Act of 1948, which Synthetics 2 has looked at, and therefore so from those days itself, industrial alcohol is within the center's control. Now, my lords, para 2 of my note, my lords, I have actually set out where all the term intoxicating is used in the Constitution. It's very interesting. Article 47, then there is Article 36629AF, and then there is Schedule 7, Entry 8. All these three places where the term intoxicating is used is in connotation for human consumption. There is one more place which my note left out, my lords, which is
Sure.
Schedule 6 of Entry 3B, which deals with special laws for Bodo land. There also it's for human consumption.
Just 1 second.
Para 2 of my note.
In Article 47, Article 366,
29 AF.
and entry 8,
Yes.
and which was the final
And
one?
then, my lords, one final which is left out is Schedule 6, Entry 3B. Constitution. All, my lords, are in the context of something which can be consumed. Intoxicating has never been used in the Constitution in the context cannot be consumed or not fit for human consumption. My lords, that's as far as intoxicating liquor is concerned. Now, my lords, the second point I want to make is, my lords, I feel, my lords, the case of Tilak Ram was dealt with. What was not dealt with in reply, I suppose, was the Calcutta Gas Company case, which follows Tilak Ram. Now, Calcutta Gas Company case, my lords, I don't need to go as far as saying, please overrule these judgments. Tikaram, I'm sorry. Calcutta Gas Company case, I don't need to go as far to say, please overrule Calcutta Gas Company to make me reach where I want to reach. According to me, if one looks at Calcutta Gas Company case and looks at the reasoning of Calcutta Gas Company case, it supports me because the way they dealt with the analysis, if that same analysis is applied, then entry 8 would exclude industrial alcohol. And I've cited a very interesting paragraph from Calcutta Gas, which was the key paragraph, where Calcutta Gas was trying to look at entry 25, which said gas and gas.
That para 9 that you quoted page
Yes,
6?
I've quoted, yes. From para 6, I've quoted it, and I've quoted para 9 of the judgment. There's a second page of the quotation of the judgment where I've underlined in bold. There, the point I'm making is that if one looks at the court was confronted with entry 25, which says gas and gas works, and the court was then confronted with entry 24, industries. Court said, if I say that gas and gas works is in 24, then of course it will fall into 52, and therefore I will entry 25 will be left meaningless. Rather, the way court was at a situation where it says, and I'll read this just 4 lines. It's from what I've highlighted and underlined, just 3 lines above that. If industry entry 24 is interpreted to include gas and gas works, entry 25 may become redundant. And in the context of the succeeding entries, namely entry 26 dealing with trade and commerce and entry 27 dealing with production, supply and distributions of goods, it will be deprived of all its contents and reduced to useless lumber. Because my humble submission is that by removing industrial alcohol from entry 2, one would not make entry 8 useless lumber. Entry 8 would still apply fully as far as potable alcohol is concerned. There was a case where the court was trying to see what would be left with gas and gas works if I put it the entire thing in the industry. So, Milots, if that analysis is also applied, then Milots, Calcutta Gas comes to my rescue. Leaving Milots to my last point, which I've made, Milots, at para 9 of my note, is that Synthetics 2 cites India Mica's case and says that within the parameters of India Mica case, if a regulatory fee is imposed by the state, and those parameters and the boundaries are set out in India Mica's case, which is time tested and recently applied in Vama Organics 2, which was read out by Honorable Solicitor General. So, Milots, as far as regulatory fee imposition is concerned, Synthetics 2 also leaves that door open for the state. So, according to me, it's a storm in a teacup, Milots, to say that we can't do anything. If you fall within the parameters of India Mica case, you can still impose a regulatory fee. Those are my points. I'm very good.
Yes, Mr. Yes, Mr.
Very short compass. My submission would be only on the phrase this alcoholic liquor for human consumption. Although lordships are looking at entry 8, the intoxicating liquor, my submissions are just twofold. The phrase alcoholic liquor for human consumption has since been long, since the Constitution has been understood as what the synthetics has said, which is to be consumed as it is. The debate has always been with regard to intoxicating liquor and the fact that whether the something other than alcoholic liquor for human consumption will also be added in intoxicating liquor. So far as there's submissions to say that alcoholic liquor for human consumption as to be expanded to mean something capable of also has never been the any judgments of a lordship except the Bihar distillery, which makes a aberration in that to say that now you can even go and impose excise duty with regard to rectified spirit, etc. This is not a alcohol liquor for human consumption. So my submission to your lordships is that with regard to this phrase alcohol liquor for human consumption, since Balsara and till synthetics too and the later judgments all have consistently as held that this phrase would mean only with something which can be consumed as it is. Whether intoxicating liquor, as what has been all argued, will also include something else, but your lordship will see, I would not wish to make those submissions on that. My only submission, I have put that how it has been followed till Utkal Distilleries, 2022 judgment of your lordships, all have taken this consistent view except the judgment in Bihar Distillery. Now, Bihar Distillery, your lordships may just note the fact that it applies a very simple test, which according to me is not correct, is the fact that it's a case of a mere dilution. In fact, it also recognizes the fact that it makes a portable alcohol or alcohol for human consumption only when you dilute it. So therefore, they imply there is an existence of a process, and the initial, that is rectified spirit, is not something which is alcoholic for human consumption. So my submission to your lordships is, one, the test that it is a case of mere dilution is not correct, as your lordships in Winbros, in the case of an income tax, has clearly analyzed the process and has said that it is not only a mere dilution, it has to be a case where it has to be put on a specific environment, on a temperature, by addition of many other things to make it fit for human consumption. So my submission to your
Have you
lordship.
given us a note by any chance?
Yes, your lordship, it's 2J, volume 2J.
Okay.
Yes, your lordship. And one last submission to your lordship's consideration. There was a submission made that, look, today, after a GST, what the states have been left with is the entry 54 is the alcohol liquor for human consumption. And then your lordship has to read it expansively. My submission to that is that, in fact, if that has been the interpretation given, there would be a substantial loss, because today, post GST, all other alcoholic liquor, including the rectified spirit and the extra neutral alcohol, all is liable for GST. So that GST also goes to state. It's not only that the center is keeping, as a lot just know, it's a federal fiscal legislation. So it goes both to states and the center. Now, apart from that, for alcohol liquor for human consumption, they have an exclusive power to impose sales tax. So my submission is that what they are losing would be, in fact, a GST in case if the expansive meaning is to be given, not there has been a loss to a revenue, because that's what Shadan.
Thank you, Mr. Pawanshi. Yes.
Blood, small submission, Blood, for 5 minutes I'll take it. Blood 901.16, SLP civil number 3160 of 2015. Blood, this SLP, Blood, subject to outcome of your lordship decision, this is to be decided. Blood, on the ground, Blood, certain duty was imposed.
What, we'll not go into the facts. You can tell us what your submission on law.
Blood, my submission is, they have imposed certain interest, Blood, for the duty because of the issue.
That
Blood,
will have to go before the regular.
Blood, the Honorable High Court.
You have to say on the questions we have been hearing on arguments on now for the last several days.
Yes, my lord. In case if your lordship is upholding the judgment, my lord, I got benefited this respondent. Suppose overruling it, my lord, the
That's all.
interest should not 100%,
That interest that you can argue. before.
180% it is coming, my lord.
All
Actually, more than a crore.
Yes, all right. Thank you.
Much of.
Yeah.
We are for Rampuchini. Just 2 minutes, your lordship, just stepping back. Now it has become a center versus state issue, which is rightly so. But it started out as me or the private party versus the state issue. And the legislation in question was the UP Excise Act, in light of which, and why we say it, because in light of the 3 issues which are before the court. The first issue is regarding entry 84 list 1 and the counterpart entry, which is entry 51 list 2. The issue regarding that is alcohol fit for human consumption. The second issue is regarding entry 8 list 2, which is intoxicating liquor. And the third issue is regarding entry 33 of list 3, which is to be, as per the other side, read along with entry 24 of list 2, which is on the industries aspect. And the counterpart entry in entry 52 list 1.
What do you have to add? apart from-
The thing add is, your lordship, in the UP Excise Act, we have to see the legislative conscious from the act itself. If your lordship will see the act, because no one has shown the act itself defines what a liquor is. This UP state says liquor is intoxicating liquor, and in what it includes, they add all the beverages. So the argument sought to be made now is contrary to the legislative conscience itself. If your lordship takes the statute for 1 minute,
Where do we get it? We just make a note and then.
your lordship, it's in volume 4, page number 682. There are 4 definitions which are important in this statute. The first is excise duty, which is at page 692. Because it says excise duty as per entry 51, list 2.
Excise duty is 692.
Then definition of liquor, which is also at page 692, bottom, your lordship. I'll just read it out. It says liquor means intoxicating liquor and includes spirits of wine, spirit, curry, panchai, beer, and all liquids consisting of and containing of alcohol. So there is no question of moving beyond these beverages or taking assistance of entry 8. The other is excisable articles, which is definition at page 696. Excisable article, they specifically mention, means any alcoholic liquor for human consumption.
Yes.
And then, your lordship, section 13, read with section 19 and 28 of the Act, says that any transport or removal of these excisable article, that is to say any alcoholic liquor fit for human consumption, will be charged with a duty. So they, in the legislative aspect, have only relied on entry 51, which as per every submission is barred by entry 82.
Thank you.
Entry 84.
Yes, Mr. Dwivedi.
Was to answer, my lord, that Tikaramji issue, my lord, if your lordship recollects, whether it is, lord, my submission is this, my lord. Lord, Tikaramji essentially does 3 things. A, it compares the 2 acts which were in question in that petition and says that there is no repugnancy in that matter, with which, my lord, we are not concerned.
Yes.
But second, which in my submission is an obiter because that was not required to be decided, is the term industry in entry 52 list 1 is restricted only to manufacture, neither pre nor post manufacture. And third, Tikaramji does not even go into occupied field and says that once there is no notified order, the scope is open for the state to step in and legislate.
Does not go into occupied.
Does not go into it and says that, but that is clearly an obiter. It was not required to be decided. There is no discussion why one view over another view. It is an obiter. But so far as second issue is concerned,
yes,
regarding the restricted meaning given to the term industry, so there are some legislations in place as on date referable to entry 52 list 1. So they might be impacted. In future, the parliament may require, my lord, in peculiar circumstances, to control, my lord, right from raw material till the end products usage. So, my lord, I'm not, my lord, respectfully, my lord, concerned with whether Karamji is overruled, affirmed, or explained. My lord, that's entirely your lordship's prerogative. But, my lord, kindly bear these factor in mind. So far as second is concerned, whichever way, the lordships may, my lord, accept our submission that there was no legal or other necessity to restrict the meaning of the term industry. It is wide meaning. And if it is not so, then even entry 24 list 2 also will be impacted. Because then state also will have only manufacturing part. So I'm not, my lord, against state. I'm saying state also would be adversely affected. These are my submissions.
Yes, Mr. Dwivedi.
Wait, please. Have filed the rejoinder submissions also for lordship's convenience. The short 10 pages only, 15 pages.
Where will you find it, Mr. Dwivedi? The
Volume 1M,
this
the screen.
PG code. Infant store.
Digital PC.
Yes, on.
Then you can scroll it actually. Yes.
Digital mode. So as I have been taught, and as I have learned over the years, and your lordships have hammered it in, and that is, we are a federal structure, but the power of the state under list 2 cannot be controlled or regulated by parliament. That's the concept of cooperative federalism. Federalism, your lordships have churned out time and again. And if I would refer to your lordship's judgment, 2000.
Would you like to read that out? We have that para 1, para A. Let's see how you have formulated it.
No, I was referring to what.
Right at the end.
So the question is not what we are being told is that 1951 IDR contained industry and industrial alcohol and other things. In 56, it was modified to include alcohol under the heading fermentation. And then 16, again, it has been changed. Now I ask myself, is the jurisdiction of the state going to conform to the law laid down by the parliament? Or can parliament, by constantly modifying and amending its own law, dictate what is contained in the state list? Lordships have very clearly said state list reserved for the states, and states have plenary power, which power cannot be controlled by parliament or by parliamentary legislation. That's not absolutely clear. But yet my friends say that entry 8 has to be guided by legislation of parliament, 1951 Act. Now I ask myself, what is being argued, in fact, is that forget what the makers of Government of India Act 1935 had in mind when they incorporated NT 31. It is same, verbatim the same as entry 8. What they had in mind when they incorporated entry 40, which is excise duty, same as entry 51, list 2. My friends further say, forget what the framers of the Constitution saw in the Government of India Act and these entries and incorporated that verbatim in the same manner as in the Government of India Act. My friends further forget the fact that the legislative history, if these Government of India Act and the Constitution entries are seen in the light of the legislative history, the legislative history contained both the things in the same manner as incorporated in the term intoxicating liquor in entry 31, the Government of India. So what we really have to see is, what did the makers of the Government of India Act have in mind when they incorporated entry 31, that is intoxicating liquor in all its facets. And not anything else. No. If the parliamentary law may say whatever it wants to, Parliament may include whatever it wants to. But we cannot, on the ground of parliamentary supremacy, justify this kind of encroachment on the state list. So therefore, what is absolutely essential is that before we go into the issue, whether intoxicating liquor means what I am claiming or what they are, or it means what they are claiming. No? Before that, we must be clear about the federal aspect that is embedded in our constitution. And the best judgment in that regard, not the latest one, I would submit Lordship's judgment for 2018, 8 SCC 501. That is at volume 5, PDF page 1299. The relevant paragraphs note I have given my note at page 1. The emphasis is quite clear and unequivocal that state powers are plenary within their own list. They cannot be tempered by Parliament. Now, what I mean,
You are supposed to give your rejoinder today, right? Why this particular document is uploaded during the court hours? We are having to stress our hand and get away from the notes that we are taking with our hands. Should have been incorporated before we commence proceedings. The technical issue and what we are having to concentrate on the law is getting diverted. I mean, at least I'm speaking for myself. I'm not speaking for other members of the bench.
I can finding ourselves, but we can't. See, there's no
So if it was done at 10 o'clock, it would have been incorporated in our devices. Why not at yesterday evening? Why not today at 6 o'clock? Don't try to give a justification 9:45. 9:45, we are getting dressed for court. 9:45, what do you do, if I may ask you, young man? You're looking at your, preparation of the court, or you are getting dressed for the court? We have the same routine. No, just that I am a little disturbed. That's all. Everybody.
I can. If I may enlighten the entire note, this was the evening whiskey which caused the problem. But my apologies, Lord. Lordship may. Extreme apologies.
It from you.
Yes, Mr. Dedi.
I was just to
Right.
enlighten the entire thing.
Yes, Mr. Dedi.
Therefore, what I was saying is,
what we have to look into is what does the constitution provide, not what does the law provide of parliament. Parliament would always be encroaching. The nature of power is encroaching, therefore always try to encroach. Now, that is why I was referring to 2018, volume 8, SCC 501, paragraphs 94 to 120, 123 to 133, 466 to 468. And then, Lord, that 9 judges judgment, Lord, of Jindal, in which Lord Justice Chanchud was there, Lord. 2017, volume 2, SCC 1, volume 12, paras 13, 16. This is PDF page 678. PDF page. PDF page 678. Given the PDF. Volume 5. I'm not, if I may, Lord, Lordship, since Lord have it here, can I place the A part of my?
Yes.
The words notwithstanding clause 2 and 3 and subject to in Article 246(3) are not unlimited. They are limited by the context, that is the basic structure of the dual polity. Admittedly, both the union and the state legislatures are plenary in relation to their fields. Both derive equal powers of legislation only from the Constitution. The states share sovereignty with the union, and that they are legislative plenipotentiates within their legislative fields. They are neither appendages nor satellites of the union, but are its co-equal. This is precisely what Lordships have said in 2000, following large number of decisions in the earliest. Therefore, keeping in the context in view, we have to analyze the scope of the aforesaid phrases. The issue of parliamentary supremacy arises only in the event of a conflict of entries. Can you note this one? It arises only in the event of a conflict of entries on the 3 lists, and not in the case of conflict of laws that attracts question of repugnancy or occupied field. Not only the entries in the union list, but all the legislative entries in the other lists are to be interpreted widely and liberally. While so interpreted, conflicts or overlaps may arise, which are resolved as per the principles evolved in Hext Pharmaceuticals Note. And I have, for Lordship's convenience, laid down certain paragraphs which are relevant. In fact, this judgment, Lord, Hext Pharmaceutical, which is kind of an authority for this purpose. It in fact says if there is a conflict between the entry in the list 1 and entry in the list 3 and 2, sorry, then the effort has to be to reconcile the conflict harmoniously. And every effort should be made to reconcile harmoniously. It is only when no reconciliation under any circumstance is possible, then parliamentary supremacy kicks in. But then for that purpose, they went to this extent, Lord, that if the central list is a general list, that's what is considered in this thing. And if the state list overlaps the central list, then carve out a space for the state list and then create whatever normally could be given to the center and appropriate space for this. It's not that we will wipe out the state entry because there is a conflict. This kind of interpretation has been followed by our lordships all throughout, and I'll show it till about 2002 ITC. The parliamentary supremacy as held in the above case is limited and not absolute. It operates only when there is a irreconcilable conflict of entries. The irreconcilable conflict will only emerge when all efforts at harmonious reconciliation fail. One of the foremost methods of reconciliation, as pointed out, is to cut down the union entry and carve out a reasonable space for the state entry. That's what the Hext says.
Yes.
So we should not attribute Lord, with all due respects, Lord, we should not attribute everything to the concept of parliamentary supremacy. We should be hesitant in going to that because Lordships have said that any interpretation that whittles down the power of the state should be avoided. And this Hex Pharma, Lord, I am informed, was reaffirmed in innovative, Lord, the station one. Bearing this in mind, Lord, just analyze what is the scope of entry 8.
So if we have to then go into the content of entry 8 as it says intoxicating liquor. According to you, intoxicating liquor includes all liquids which are alcoholic. And therefore, it's not really something which is only which is portable or for human consumption. Can you just formulate why you are why that interpretation
exactly.
you're really
I've given a cogent reason for that.
just. So, Mr. Dwivedi, just tell us if you can summarize them in points.
Yes, yes.
Why intoxicating liquor, as you say, means all liquids containing alcohol. These are the words you have used in a written submission.
Quite right.
So let's just take it down step by step. Just give us the reason.
This was what was in the mind of the makers of the Government of India Act 91.
All right. Just one second. This was how. First. In 1935 construed the phrase. Now, when you say this was how the makers of the GOI Act 1935 construed the phrase, what is it? How do you support it?
Yes, Lord, when we see entry 31 in Government of India Act 1935, then naturally we'll have to find out from where did they get this.
What is the entry? What is entry 31? Can you just
indicating the verbatim the same as in
verbatim the same.
Verbatim as in entry 8. Include certain other items with which we are not concerned, so I was not wasting. And when it came to entry 41, another important thing is which
what did it include apart from opium? Sanskriti, is that in somewhere in one of our compilations? Entry 28. Oh, sorry.
As written submission.
So that we don't have to again hunt for them. Can you just tell us which volume? Vishal Mehta, Sanskriti?
2D.
Page 28.
In the yes.
Yeah, we got
Government of India Act. I've got the Government of India Act.
Yeah, we also got it now.
Yes.
Entry 2D, volume 2D, page 28.
Yes, Lordship will stop at intoxicating liquor. From the word starting with opium, the narcotic drugs, but subject as respects opium to provision list 1, and as respects poisons and dangerous drugs provisions. So up to liquor is intoxicating liquor. That is to say, the Lordship now compares right from opium to the end. All the other words are denied. And I would request Lordship to ignore that,
Yeah.
that's not relevant for us. Lordship wants the original text, I got it.
Yeah, that is to say the production, manufacture, possession, transport, purchase and sale of intoxicating liquors.
Stop.
So everything from opium up to the end is deleted and narcotics, drugs is. Yes, all right, we got it. Then
Number of the question is not what did they have in mind and where did they get this from? There is entry 41 also of the Government of India Act, which is important. Lord. Entry 41 is the taxing entry, not excise duty, which is verbatim in the same form as it was the Government of India Act, entry 41. Entry 51, list 2 of the Constitution is verbatim the same, Lord, so far as the relevant part is concerned, verbatim the same as entry 40 under the Government of India Act.
entry 40, right?
Entry 40, Government of India Act 35. Now the question is, these two phrases were not new phrases. These two phrases were not which had not dawned all of a sudden to under the Government of India. These two phrases are well understood and utilized in various local acts, excise acts. And that is where I'll pray, kindly have my written submission, Lord, original written submission, and I'll refer to 2-3 pages only. Because that's the keystone of my entire argument, Lord. Both entry 31 and entry 40 in the Government of India Act were verbatim borrowed from the local acts. Now, Lord, it is, if your Lordship would kindly come to my usual written submissions, Lord, volume 1, A, page 8.
Yes.
I had referred earlier also, but then Lordships want to know.
And according to them, according to you, therefore, that this had meaning, it was not a meaning which was
Exactly the
confined
same
to,
word.
it was not confined only to potable liquor.
Yes, initially the local acts used liquor, which included all kinds of liquor, all liquids containing alcohol, including denatured. Then, Lord, comes the Madhya Pradesh Act, Lord, at page 10. The convenience, I have only quoted the definition clauses, Lord, those acts. Lordship would have page 10. MP Excise Act, excisable article.
According to you, the meaning in the local acts was
Adopted.
all right. Then what is the next point, Mr.?
So, but kindly just have a
So
look
we've
at
got your point that entry 31 and 40 were borrowed from the local acts, and therefore they must have the same meaning as in the local act, which
and
includes.
what I wish to point out here is not my sense on for entry 50 and 40, list 2, sorry. The Government of India Act follows the definition of excisable article, which says alcoholic liquor for human consumption. Excisable obviously means tax. So it uses that phrase. But when it comes to not liquor, which is to the act, it means intoxicating liquor and includes spirit, wine, spirit, and all liquids consisting of or containing alcohol. Spirit is defined to mean all liquids containing alcohol. So what is interesting here is, Lord, none of these acts, when it comes to regulatory power, dissect between the industrial alcohol, the denatured spirit or the rectified spirit and the potable alcohol. They don't. None of the acts. And these acts were of vintage 1915, 1908, 1910, 1912. The only dissection which these acts had was in respect of excise duty, where it was said alcoholic liquor for human consumption would go there. And of course, the Dominion wanted its share of the pound of flesh. Therefore, they said we'll have the industrial or the non-portable excise duty. The Constitution has verbatim borrowed and adopted the same system. Now, I ask myself, for excisable article for the purposes of levy of excise duty, the phrase used is alcoholic liquor for human consumption separately. There's a dissection. Rectified spirit and denatured spirit may not fall there, but for human consumption, therefore, bottom. But if the idea was to have the same meaning here of liquor and intoxicating liquor, why would they not put the same word here? But instead of that, all the acts unanimously did not dissect for regulatory exercise of power, not the liquors. In fact, if your lordship would see section 213 of the liquor and all the acts, it says all liquids containing alcohol, which means alcoholic liquor. So alcoholic liquor was in the regulatory regime, while the alcoholic liquor for human consumption was for taxing regime. It was the dissection created by the local acts, followed by the Government of India Act. And why do I say please adopt this legal sense? Because the lordships have in Gannon Dunkerley, lordships were confronted with this similar issue exactly. Taxes on sale of goods. That was the word used, the Government of India Act. Lordships went into a history. How did this term taxes on sale of goods come? And then the lordships said that we must see the legal history of the term. How was it used in England as well as in India? And then they hit upon this Sale of Goods Act 1930, which was close proximity to the Government of India Act. And they said that definition must have prevailed because that was the legal sense prevailing at the time when the makers of Government of India Act applied their mind. But it's not that everywhere we adopt this area of popular sense or any other sense. Question is, Gannon Dunkerley Constitution bench clearly says, if there is a choice between popular sense or the legal sense, then we will adopt the legal sense born out of history, legislative history. This is not 1959. But if a lordship would say, Gannon Dunkerley is 1959, volume 1 SCR 379. It is volume 5B. Sorry. In fact, they discarded the popular sense and said no, it's sense in which it was understood by the makers. And what was that sense? Legislative history. Sale of goods. Now I ask myself, what is the difference between that case and this case? Note, why should that principle not be adopted here? The question to be, as I said, note, I repeat again, the question to be asked is not what the makers saw and thought, but the question to be asked is what the makers of the Government of India Act, that is British Parliament, saw. What was the legal sense prevailing in which they saw the term?
Omar, you cited Justice Chagla's Balsara judgment. Can you just give us that cross-reference once again?
That judgment is again based on wrong and
Can you
We
just go
should
to that, Mr. Because that's the con. We have Balsara, which reverses Chief Justice Chagla's interpretation.
Balsara is the only case with legislative history, no other case.
Right.
Even synthetics doesn't deal with the legislative, it's silent on that. Balsara is the only case which had adopted, in my opinion, the right approach as indicated in Gyanam Dankali, though it did not notice that judgment, but verbatim the same situation. So the choice before your lordship is to whether to rely on the legislative history and the legal sense which prevailed at that time, or to adopt some kind of a popular sense which may keep on fluctuating to will the entry. And that is the difficulty I sincerely wish to point out. My friend says in 51, IDR included power alcohol and industrial alcohol. Then in 56, they changed it to alcohol, which means even potable alcohol. Then in 16, they again changed it. And then my friends say, please rely upon the Law Commission's report and the legislative debates of Parliament. How can they possibly not solve the riddle? I ask myself, not for your lordship. The issue is the interpretation of a constitutional entry. And entry 8 does not conflict with any central entry, the central list. So there's no issue of conflict. And if my submission is correct, that entry 8 includes, as I'm advocating, then perhaps where is the conflict, I ask myself? Where is the occasion to attract Article 246 of federal supremacy? Federal supremacy certainly cannot mean that we can snatch every entry from the state list. Because fact is, if your lordship would recall, 369, Article 369 clearly enabled Parliament to legislate on any state entry for a period of 5 years. Therefore, virtually every entry was within the way of Parliament. But 369 was given a limited life of 5 years and expired. But should we still continue to adopt that? But there would be another confusion which I may indicate if lordships would not adopt my interpretation, but this word intoxicating liquor. Intoxicating liquor contained all liquids consisting of alcohol. And therefore, under the Excise Act, they were being regulated, even medicinal and toilet preparations were being regulated therein as liquid containing alcohol. The non-potable liquor was also being regulated under the Excise Acts, local acts. Now, I ask myself, if we limit the definition of intoxicating liquor to potable alcohol, then there is no entry in any of the lists which provides that regulatory power will be exercised by any of the state or the center in respect of alcoholic liquor not for human consumption. Where will that go? I ask myself. Likewise, medicinal toilet preparations containing alcohol, where would they go? I ask myself. And the answer has been provided. The Indian mica and macanite constitution bench of 71 says certified spirit and industrial alcohol, which is raw material to macanite industry, would be covered here, entry 8. And Lordship would recall, Lordship has seen Southern Pharmaceuticals, where medicinal toilet preparations containing alcohol were included in entry 8. But the whole situation is we have been following the legislative design created in the local acts, so far as alcohol is concerned. That has been followed all throughout the Government of India Act, and from there we have adopted it in the Constitution of India. Now we are saying segregate because the IDR says so. IDR wants, Parliament wants, maybe so. The desire of Parliament, every power structure wants more power. As the saying goes, the popular saying goes, "Dil always mange more." But question here is, can we curtail the scope of that entry? That's the point note which I was emphasizing on. And we cannot unless there is a very cogent reason to show otherwise. Merely because industry is included in IDR. Now, some of the arguments were that industry, if intoxicating liquor, let's test it another way. Some of the arguments raised were that the intoxicating liquor, being potable liquor, will fall under entry 8, but the non-potable liquor will go toward industry in entry 24. Because if it doesn't go there, it can't go to entry 52. Now, Lord, I ask myself, Lord, if the framers into the background for adopting the scheme of Government of India Act and the local acts, why would they put alcohol not for human consumption in word industry in entry 20?
The Constitution uses the word intoxicating
I'll
both in Article 47 and in entry 8. Right? So if it is used the same expression in both these, then that expression intoxicating have a different meaning in Article 47 and a different meaning in entry 8.
Well, and I'll show
And
why.
if it is to have the same meaning,
Yes.
then in entry 8 also it has to be intoxicating for the human being, isn't it?
I'll answer that. There's no difficulty in that. Patient word certainly implies the human factor. That it should be intoxicating to the humans. But does it mean that it should be as a beverage causing intoxication to the humans? Or can it mean also liquor which is capable of causing intoxication to the humans? The dictionary says intoxicating means both the things. That causes and is capable of causing intoxication.
But
to
what
humans.
is capable of causing is not something which is drunk normally. A beverage is a normal drink.
I'll tell you what,
It is an abuse of that.
that may not be due respects. That I'll
Chief Justice Chagla, my learned brother, Justice Rishikesh Roy just pointed out, in the opening paragraph makes a distinction between the consumption of drink and foreign liquor and its application. And he then refers to also the fact that, can be used, for eau de cologne. He's also accustomed to the use of eau de cologne and lavender water. So they made that distinction in the very first paragraph.
What part is, and I went through that judgment more than once, no? Does it at all, I ask myself, refer to the legislative history, the Government of India Act? Because that was an act, remember, that was an act made under Government of India Act.
But we may just benefit by reading the first sentence of Chagla's judgment.
Yes.
Yes.
Let us read that first sentence. The volume 5F 429 Omer.
Yeah.
To
429.
drink, the other is to use.
The first paragraph, Lordships refer to. Yes.
Chagla, that's all.
This is a petition by one Pram Nusirwanji Balsara, who is a citizen of India, has in his possession 1 bottle of whiskey, 1 bottle of brandy, both partly used, 1 bottle of wine, 2 bottles of beer, 1 bottle of medicated wine, 1 bottle of eau de cologne.
Good old Balsara would probably not realize, at that time, that he would be still living in the annals of our history. Partly used.
No.
Anyway.
The sentence should be finished.
Lavender water and some bottles of medicinal preparation. He alleges that he has been.
Before that.
No, before that.
Medicated wine.
Immediately after that.
Medicated wine, then rest of it, please read. 1 bottle of medicated wine.
1 bottle of medicated wine, 1 bottle of eau de cologne, 1 bottle of lavender water, and some bottles of medicinal preparations.
We have an entire picture of Mr. Balsara captured by Justice Chagla in that one sentence.
Now, my lord, finally notice that this is in the context of the Bombay Prohibition Act, not the Bombay Excise Act. I have placed before your lordship not the Bombay Excise Act, but the definition of liquor includes everything. But besides the point, Lord, since your lordships were
Next sentence also,
very well.
what he drinks and what he uses.
That's important.
Yes.
But that was the case confined to what was caught with him under the prohibition law. And therefore, what he was trying to explain was in terms of what was caught with him. Those were drinks, there's no difficulty. But the point is, does it necessarily mean that whatever he had will confine the jurisdiction of the state under Entry 8? But I am on an issue where the legislative entry of state, which your lordships have not said not is plenary for the state, would it be confined to these drinks only? As the legislative history shows, from local acts to Government of India Act and then the Constitution, it does not. The question here is not lordships were, perhaps it seems affected by the word intoxicating drinks coming in Article 47. But kindly notice last 2 lines very carefully. The state shall endeavor to bring about prohibition of consumption except for medicinal purpose. That means prohibition of consumption except for medicinal purposes of intoxicating drinks. In other words, medicinal purposes would always be their liquid. State can control, but it will not prohibit. And you notice the distinction. But prohibition is for drinks which are consumed as it is, not beverage. So what 47 is advocating is that you prohibit the consumption because the idea was prohibition. But you will not prohibit medicinal purposes. State will not prohibit medicinal purposes, though it may regulate that. Of intoxicating drinks. Now, word is intoxicating drinks, which normally one can associate with the consumption as it is the beverage. But if the idea of entry 8 was the same, then why not use the word intoxicating drinks there, I ask myself. Why have different words for the same thing? At every place, note, entry 8, then perhaps note entry 47, then perhaps note in entry 51, list 2. Why do they not, again, there's another answer to it, not why the framers use the phrase alcoholic liquor for human consumption in entry 51, list 2? If it meant beverage, as in entry 8, then the same thing could have been used here. I ask myself why, not the question, not the immediately crops up, not why use two entirely different phrases to denote the same thing. It was very convenient. They could have used, if intoxicating liquor meant always the liquor which can be had as it is and consumed, then the same could have been used in entry 51 list 2. 51 list 2 doesn't use that term. But instead it uses the term that was there in the Excise Acts. It follows that. When the Excise Act distinguished and dissected between the liquor that is potable goes to the excise duty and non-potable goes to the regulatory. But I'm not, again, not, I would be kind of repeating myself. Intoxicating liquor borrowed from the Excise Acts. Alcoholic liquor for human consumption for entry 51 list 2 borrowed from the Excise Acts. Then why should we confine the meaning of intoxicating liquor? It has been borrowed from the Excise Acts. Not word intoxicating has to be understood widely. Your lordships have always said interpretation of an entry is always wide. So let us interpret it widely. Would it not include both liquor, which when had as it is as a drink, causing intoxication, or liquor capable of causing intoxication to the humans? For instance, rectified spirit, Lord, as I explained earlier, rectified spirit is nothing but alcohol which is diluted by pouring water into it and then drinking. As I had given an example, Lord, even normal whiskeys, normal people have it with soda or water. But then it doesn't cease to be intoxicating when it is in bottle.
So what is the proposition? What is the proposition that you formulate?
The proposition is this, Lord, that the word intoxicating liquor has to be interpreted in the light of the legislative history.
Yes.
That is the legal sense. And therefore will include all alcoholic liquors containing alcohol. This is because Gannon Dunkerley says so, Lord. I submit with respect. Look, this judgment of Gannon Dunkerley, which I wanted to place on the earlier occasion, I'm sorry. document is Gyan Dankali's case. Kindly have that judgment, but I will not place it for lordship. I have at page 4 of my rejoinder written submissions, I have referred to it. 1959, volume 1, SCR 379. It's in volume 5, 5B, B for Bombay. I'm sorry, but the term comes, Bombay comes really.
B page
Page 486, PDF page.
at
But the judgment pages are not 391 SCR 379, pages are not 390, 391. Three 391, 397 to 416. And it's a classic case where they considered whether they should accept the popular opinion or the legal sense. They said, no, we should adopt the legal sense. And that is why Lord Gyan Dankali adopted that legal sense, referred to large number of decisions. So that gives an element of certainty. Otherwise, it will keep on vacillating. Secondly, Lord, the another important aspect of this argument is entry 51 list 2 is a taxing entry. Our lordships have settled it more than once, note that taxing entries are separate, the general regulatory entries are separate. And they do not cast any kind of shadow on each other. Now, here is the case where we are being told to interpret the regulatory entry in the light of the taxing entry. Should that be done is the question. But if Lordship would permit me to place this, I have elaborated this, these 5-6 points which are essential. And that will conclude the matter earlier.
yes, let's quickly go.
Yes. Page 3, it begins, no? This is PDF page 4, perhaps. It begins.
Yes.
The scope and expanse of the word intoxicating liquor, short note IL, have already been explained in my written submission at pages 2 to 20 under the heading A1 to A7. There is a need to analyze this phrase in light of the legislative history as explained above. I've not got it. The question to be asked is not how the framers understood it, that is its legal sense, but as to how makers of the Government of India Act 35 saw it. When they coined this phrase, IL, the legislative history, as in US or UK and the local excise laws and all, had already determined the meaning of intoxicating liquor as including all liquids containing alcohol, including denatured spirit, medicinal toilet preparations containing alcohol, etc. With this background, the makers of the Government of India Act utilized the phrase intoxicating liquor in entry 31. They further used the phrase alcoholic liquors for human consumption. Not the word is not fit for, but for. In entry 40 list 2, it is therefore reasonable to assume that they utilized both intoxicating liquor and alcoholic liquors for human consumption in the same sense in which they had depicted in the local laws as shown in pages 8 to 12 of the written submission. If the intent was otherwise, then the framers and the makers of 35 Act would have simply used the same phraseology in entry 8 list 2 as in entry 40 list 2 of the Government of India Act 35 or entry 51 list 2 of the Constitution. The two entries use different words and therefore have to be separately seen as in the light of the legislative history. The sense that emerges from legislative history is the primary sense as can be gathered from the following cases I have referred to. There is no parallel legislative history in any of the lists that may confer regulatory or controlling power in relation to alcoholic liquors not for human consumption, medicinal toilet preparations containing alcohol. The absence of any general regulatory power as above in any of the lists further corroborates that they were assumed to be under intoxicating liquor in entry 8, list 2. This again as per the local acts. That the local laws clearly defined and equated intoxicating liquor with all spirits, all liquids containing alcohol, including denatured spirit. The denatured spirit was a spirit being included in intoxicating liquor. This also is a way to, in a way, explains why word alcoholic liquor for human consumption not used in entry 8, list 2. There is no liquor that does not cause intoxication. Even denatured spirit causes intoxication. It has been denatured to prevent people from consuming it. But what happens is when the denaturant is put, as per the local excise laws, a denaturant is put that makes it nauseous. Therefore, you don't have it. But it's not that the alcohol content goes. Alcohol content is there. There is a renaturation process. You can renature and then have. Therefore, to cut down regulatory entry 8 with the aid of taxing entry 51 list 2 by equating the two would not be very constitutional. Entry 8 is an entry that uses general words and therefore has to be interpreted widely. It is not made subject to any entry, unlike entry 24, 26, 27. Therefore, to make it subject to entry 52 would be impermissible. The dictionary meaning of the word intoxicating includes both the liquor that causes intoxication and the liquor that is capable of causing intoxication. I have annexed one of the meaning. It is further not permissible to determine the scope of entry 8 list 2 in the light of parliamentary laws enacted post-constitution and entry 52 list 1. This is amply settled by the above constitution benches. Otherwise, there would be grave risk of making the state appendages of the union, destroying the delicately balanced federal structure. The above shows why intoxicating liquor in entry 8 is wider and different from the phrase used in entry 51 list 2. It cannot be cut down by entry 51, taxing entry. Following points need to be analyzed, and this is a reiteration of the same, which I have indicated above. Accepting, Lord, if Lordship would have it from page 7 top note. The Constitution does not use industrial alcohol. This phrase is not a constitutional phrase. Not there anywhere in the Constitution, any of the entries. And there is no general entry under any list stating industrial alcohol. If intoxicating liquor is potable liquor, it is clearly shown, while IA is nowhere shown, industrial alcohol is nowhere. To be traced, therefore, nowhere shown, to be traced by the courts to complicated logic. There is no entry for medicinal toilet preparations containing alcohol, etc. The reason is these were all included in intoxicating liquor, always as legislative history shows. Now, there are two cases not which deal with the industrial alcohol. Incorporating it in 8. Indian mica and maconite, paras are given. Then in 1980, volume 2 SCC 441, paragraph 12, 15, 16, 17. No, this is, yeah, this is first synthetics, the earlier. Then I have also already referred to that Southern Pharmaceuticals, which includes medicinal toilet preparations containing alcohol in entry 8. Expressly includes. That is 1981, volume 4 SCC 391. 1981, volume 4 SCC 391. This is PDF page 1985. We have, then up to page 8, Lord, I have given the reasons why intoxicating liquor would include all liquids containing alcohol. Then comes the next point, Lord. Scope of entry 52, list 1. Lord, it is quite uncanny kind of a thing, Lord, that this question of word industry in entry 52 is wide and expansive and includes both raw material and the end product. Of course, I've referred to the judgments which have rejected this contention. But my friend relied upon the debates which he had annexed with the written submission. But before that, Lord, there is one judgment which is so well directed as well as well considered, I mean, where this point is well considered, is 1996 Allahabad, full bench, 1996 Allahabad, 135. The full bench, AIR 1996 Allahabad, 135, the full bench judgment. This is volume 5, PDF page, volume 5, PDF page, 2274. And kindly permit me to place this judgment, Lord, and I'll place what my friend had placed in support of his debate. In fact, that supports my cause rather than their case. In fact, the debates prove that the Tikaramji was correct. Volume 5, PDF page 2274. And the relevant paragraphs I may give to you, Lordships. Paragraph 7 to 9, 12 to 21, 12 to 22, in fact. 32, 39, 47 to 51, 53 to 64. All these arguments were raised in the debate before the drafting committee, and the drafting committee rejected the claim that the end product regulation, which is incorporated in 18G and then 33, should be put in entry 52 list 1. That was expressly argued, pressed, and the drafting committee rejected this submission and said, no, we'll put it in this 3, entry 33. The reason was, they said that we need states' cooperation in these matters. Cooperation where they know the local condition and they will accordingly devise their ways and means. That is what the Lordships refer to cooperative federalism. Entry 33 is about that only. It refers to all that my friend had annexed. Lordship want me to place it for Lordship. It's an interesting reading. That's why I was.
So shows just the relevant part, one para, which is.
No, the relevant part is not in one paragraph. That's the difficulty. It's in various paragraphs, one after the other. But the relevant part regarding the debate.
You can just formulate, the question is formulated at para 1. You may read that and then you may read the conclusion. Justice Khare judgment. Whether by virtue of section 18G.
Whether by virtue of section 18G of the Industrial Development Regulation Act 51, the state legislature stood denuded of power to legislate regulating supply, distribution, and price of this a product of sugar industry, and was consequently incompetent to enact section 7. This is the case where the molasses, which is byproduct of the sugar industry and therefore raw material for liquor industry. So this was an industrial byproduct, which is product of the, the sugar industry, manufacture, which is a controlled industry. Therefore, where will it go? That was the question. 33 list 3. And then in at least 5, 6, or maybe more, they have come to this conclusion that the framers had clearly rejected this ground that the entry 52 should be wide and it should include the end product regulation as well as other things, raw material. And they confined it clearly to production, leaving it 2033 is where states could also exercise power. Cooperative. And this is where they examine from page para 16. Paragraph 16. Again, the same logic, not the legislative history, has to be looked into. But it starts actually from paragraph 14, where the judges have not utilized Shiva Rao and his narration of the debates and so on and so forth. Then it goes to 16, where they clearly hold that the debate, the drafting committee rejected the claim of putting it in entry 52 list 1. And then their lordships go into the issue of how to examine the entries in the light of the federal structure features. And then they deal with surprisingly, every time this question was raised by eminent counsel Bhushan, every time, because he was generally, he was the leading lawyer for the sugar industry, so therefore this question rose frequently, and he raised it up till 2002, Lordship. Same argument. The uncanny part is, that the same argument is raised time and again, relying upon the IDR Act for curtailing the expanse of states' power under entry 30. And the same argument is rejected time and again, and I have narrated those 8-10 decisions where this has been rejected, at times with a reprimand. So this judgment, if read carefully, categorically, rejects and dismisses their contention. That industry word in entry 52 list 1 is very wide, to include the end product as well as the. Now, this judgment has been affirmed in 1998. 1998, 7 SCC, page 26. In fact, not the lordships need not take the trouble of writing it, but I have indicated in paragraph page 12 all those cases where this has been approved. Page 12, kindly have. And can you see the times in which the number of times has been rejected, and at times with a reprimand the council for raising this. It starts from 56 SCR, that's the first case, goes on till 2002. Not the other ones, but 2002, volume 9 SCC. This is ITC. And interestingly, the Sri Shanti Bhushan has been raising this argument from 1980. That is Khaitan, 1980, volume 4 SCC. Every time it was rejected. Now, again, the same argument is being raised on the basis of very same debate which has been repeatedly rejected.
What else, Mr. Vedina? What else remains?
Yes. My lord, the question is, but this is not only approved in Sriram Industrial Syndicate, but this is approved in Belson, the Constitution Bench. This is again approved in ITC, this judgment, full bench. In ITC, which is 2002, I have narrated in page 12 of that. Again, the paragraphs. Then kindly come to page 10 of my this thing. Page 9, I have narrated those cases which have upheld.
Yes.
Then note page 10. The important aspect is not which one of the things which my friends are raising, not this document, this argument of a composite kind of a law made, which is code unto itself. Therefore, even if you don't legislate anything under the law,
Forbearance has
rule is taken because there is regulation by abstinence as well. Now, there are two things which I wanted to point out. Kindly have 18G.
We'll come back after lunch.
Apologies to Justice Roy in the first place, but I have given a submission 1-0, but I gave it this morning because all the submissions came on Tuesday afternoon. I was in Calcutta yesterday, but I hand wrote everything, got it typed. So I won't refer to it, Lord, since it was after 10 o'clock, but I will just.
It can be incorporated at lunch now. You can just give it to the court.
Already given in the morning, but since Lordship said not.
Put it on the drive now.
But in fact, Lordship may make it as a part that all submission must come 24 hours in advance. So then all of us will. But this, what happened was all the submissions.
My apologies, Lord, for the inconvenience, Lord.
No, not to you, but I think Samar Vijay, right? Samar Vijay, actually, I should not have spoken in that fashion. So firstly, my, regret that these kind of words came out. But let me just put this thing. You see, when it is all paper court, whenever arguments are, we are making notes with our pen, ink, pencil, whatever, right? Now, this 9:45 thing has deprived me of this. That is the thing, right? So don't take it this thing. It's just a matter of convenience only. That's what we say.
In 1-0, I was just attempted to answer this 6 questions referred by Lalta Prasad. Ironically, entry 8 was never referred to, but we have argued most on entry 8.
That's right. Mr. Dwivedi, another 15 minutes so that then we can hear Mr. Datar for about.
I'll take, I'm not going to have rapid fire, just 25-30 minutes. Just 3 points I'm going to go.
But what I intend, subject to your Lordship's approval, you noted their submissions. I can't argue. There can't be a surrender. And their new fresh argument on one side and our response on the right side will file by tomorrow or day after.
Then they'll go on. Then we'll keep it at that now. So
there are some new
they will also respond to that. They will also then respond. It will be like impossible.
I leave it to you.
So, Mr. Dwivedi till 2:15, then 2:15 to 2:45, Mr. We'll wrap up by 3.
My Lord is sitting in alternate bench.
This will never end. Right. We'll see after Mr. Dwivedi ends. First, let Mr. Datta start at 2:15. 2:43 we'll. Then we'll see how much time we have.
1-0.